Welcome everybody, another night at Open Security Summit, and we're discussing again Shrems II and any workable solutions to work. So without further ado, I'm going to hand it over to Adam. Adam, take us away.
Hey folks, so intros first, and then I'll just talk through what we did last time and what we've done since and what we can potentially do today. So I'm Adam Leon Smith. I'm a fellow of BCS, a British Computer Society, and I'm also Chief Technology Officer of Dragonfly, a UK consulting firm. Also, we've got Carrie, Dennis, Mark, and David Clark with us contributing. Should we go in alphabetical order? Carrie, do you want to introduce yourself first?
Sure. So my name is Carrie Lenning, and I am a data protection consultant that is originally from America, as you can tell by the accent, but now living in Dublin, Ireland. And so I like to opine and shoot my mouth off about things that I probably have no business talking about. But, you know, sometimes I'm right.
Dennis?
David technically is first, right?
Oh, yeah.
Alphabetical.
Good point. David.
Hi. Yeah, David Clark. Yeah, I've got a background in cybersecurity and data protection. I do a lot of work with all different size companies in that field. You know, I see that there's a lot of overlap, and hopefully try and fill some of those gaps. I also run the largest GDPR LinkedIn group. Yeah, and that's about it, really.
Right, I'm Dennis Cruz. I'm the CISO and CTO of Glasswall. I also kind of help and lead the Open Security Summit. I've been doing application security and security for quite a long time. And I think this is a great topic which intersects a lot of the stuff, again, that I'm passionate about, from privacy to security to technology to human relationships to political sort of movements. So it's quite an interesting and topical area. And Mark?
My name is Mark Potkowitz. I'm another American who can't resist the opportunity to shoot off his mouth. I'm an attorney by profession with a background in federal legislative policy in the states around tech and privacy.
Great. James, do you want to introduce yourself as well?
Yeah, I can do. James Bohr. I do various security bits.
So,
Nice and brief.
we have lots of other people on call as well, and this is a contributing. Yeah, please just jump in whenever. And when you're first talking, it would be great if you could introduce yourselves as well.
Great. So where did all this all start? So the British Computer Society, the legal specialist group, did a briefing I participated in a couple of months ago now around the Shrems II decision and what that meant for international data flows, particularly in the context of the United States. We then had a joint session between the BCS and the Open Security Summit, I don't know, about a month ago, I think. And we started to talk about what a reference architecture could look like that kind of solved the Shrems II problem by turning SAS on its head a little bit. And we really focused on emails, SAS emails. So lots of us use Microsoft Office 365, lots of us use Google Apps. Most SMEs in the UK use that kind of solution. And we talked through some of the problems, talked about some ideas about how it could be solved. Since then, 3 or 4 of us have participated in a Google Doc, writing up some of the history of Shrems II, the proposed architecture that we discussed last time, doing the work to assess it against the latest EDPB guidance. And I think we can go through some of that today. The interesting thing as well is that it's now becoming very clear that the UK isn't likely to gain an adequacy decision. So what started off as a conversation about the United States has a whole new spin on it now around the UK, around Brexit, around how EU companies deal with the UK, around how UK companies deal with the EU, around how companies that have staff in both regions, how you cross the border between Northern Ireland and Ireland with a mobile phone full of names and numbers. Whole raft of issues in there, which I think we can get into today. And there's also a British Computer Society webinar next week, again with the legal team, talking through some of these issues in another forum. But I think today we can focus on kind of some of the technical proposed solutions that we talked about last time. So I posted on the chat a Google Doc. So that's hopefully everybody can access that. I think probably if we step through it and kind of the people who've contributed each section can just talk through a little bit, not read the paper, but just summarize some of the work in there. And then we can jump in at any point. If anyone's got anything to add, any questions, just jump in, introduce yourself, and let's start talking. And I think there's two.
Share your screen, Adam.
Yeah, can you share your screen? I was gonna say.
Yeah, I can do that as well. I think there's a couple of areas that I think we're a bit weak on at the moment in the report, and that's why this should be an open source architecture and a conclusion. So it'd be great if we can progress those two areas kind of dynamically as a group. Let me share my screen. And following today, we're going to put this into Markdown format and put it into GitHub.
Yep. And I think it would be good to also like just make sure that we sort of align on a solution, right? Because I think you kind of cover that there, but I think let's just, if we can, see if we can zoom in on that, like what is that one solution that we think has legs, right? Which then, then we can simplify it, right? Then we can just even create some simpler documents or simple stuff that just, this can become the reference implementation, right? Or the detailed stuff. And then we can almost start talking about the implementations of the solution. So yeah, go for it.
Great. So Mark, do you want to summarize the history?
Sure. In broad strokes, there's a lot of history behind this. And so those who know me know that I tend to be long-winded and have trouble relying on concision. I'm still sharing your screen. Great. So one of the things I just want to say is that anybody who wants to add to this or thinks that I have mischaracterized something, feel free to jump in. But in broad strokes, the way that I describe the history of the Shrems II ruling is talking about the initial Snowden disclosures, which prompted Maximilian Schrems to begin his kind of litigious journey with the data protection commissions, et cetera. And in short, he became concerned following the Snowden revelations that the US government might be accessing his data, and through a series of lawsuits in public activism and other advocacy, eventually led to a couple of rulings, one of which invalidated some earlier frameworks between the US government and the European Commission, which allowed for cross-border data transfer, and then invalidated in many ways the second framework that was created to replace the first framework that he had invalidated through his litigation. So we're now at a point in time of having just received a new decision in the 16 July 2020. We are exploring ways to comply with the framework. To my mind, with my reading of the opinion, the crux of the issue here is that the court is seemingly maintaining that it becomes a violation of the European regulations to send data to a jurisdiction where that data is not afforded the same legal protection, so long as the data covers EU data subjects. So if and until the United States adopts a framework that is similar to the protections or equivalent to the protections of GDPR, we are seemingly in a peculiar situation. Is that a fair characterization?
Yeah, the only thing I'd add is that the court specifically called out the idea that in addition to the lack of adequacy and rules around protecting user rights under the GDPR, it was also the fact that there was no redress. The court called that out a couple of times. And so I think that is, like, I think, it's a difference between, say, like what the California Consumer Privacy Act is versus whatever mishmash the federal laws have. Like the CCPA kind of gets close. But it still doesn't have much in the way of a redress right. So they would still probably be considerably inadequate. So.
Well, what do you mean by redress?
So when the court was talking about, part of the problem is that, a FISA 702 warrant or the executive orders don't allow providers to give notice to a data subject that their information is being obtained. And they don't allow that person, in many cases, to object. There's no right to bring a cause of action. If you are not a US citizen, you don't have standing, you don't have the right to bring a case. And so that creates problems because there's basically no accountability. There's no policing of the government's surveillance powers. And Mark, feel free to pop in if you got a thing you want to add there.
Sure. So, part of the earlier ruling and the subsequent one pointed out that when it comes to these processes, it isn't the adversarial process we would typically have in a judicial proceeding. So as a consequence, not only would somebody not be on notice that their data was being collected, but there would be significant issues, to echo what you're saying, Carrie, about the issue of challenging whether or not it would be appropriate. Furthermore, if for somehow you're even able to mount a challenge in some inconceivable fashion to it, the kind of ameliorative steps that would be taken wouldn't necessarily make anybody whole if we presume that there is a de facto harm caused by the invasion of privacy.
Right. Assuming that the
So,
court didn't
the
just
language-
toss them for standing or some other, procedural
Exactly.
reason in the first place. Yeah.
Right. So would you be more comfortable then with the summary where I talk about, in broad strokes, the level of protection, if I added a sentence or two talking about the availability of judicial process and being put on notice of data collection?
Yeah. I think that would probably be good.
Can we talk about tempora?
Like the Japanese food?
No. The tempora is the undersea cables issue in the UK. So there's a reference to this a bit further on. Reference 31. So this is all about the sniffing of metadata and deep packet inspection on the UK's undersea cables. One of the things covered in here is the fact that the legal basis or the objectives of tempora are redacted. And I would assume there is also, I'm not aware of any redress.
Right. I will profess complete and total ignorance of this. I have not read this or heard of tempura. But I wouldn't be totally shocked given what other brilliant minds in the field have talked about in terms of the UK government's surveillance state, that they would fail for the same or similar reasons as what the court was citing in the US.
Here's the reasons they're allowed to use it, including **** and ****, but they don't look at ****.
That's helpful. Yeah.
This paper includes the word redress once. Well, maybe not if people aren't familiar with it, but I have referenced this further down when I've said that the UK is unlikely to gain an adequacy decision.
I don't necessarily know if I would go so far as to say that they won't gain an adequacy decision eventually. I think that it will just take some time. So again, I guess maybe I'm a little bit more hopeful after listening to the Irish, Data Protection Commission today talk about this. As someone was asking, is it ever possible? And it's always, the answer is, if there is a political will, there is a way.
But really, it's kind of, France does the same thing. Yeah. It's only the the four main countries of the world who do the same thing. The rest, in reality, don't kind of really matter. So they're never going to give up those type of rights to be able to look at that type of data. Right.
And so the question is, of course, what kind of political compromise could potentially come out of this? This is further afield.
Is this a case where, while the UK was in EU, it was probably too big of a fight to everybody to buy, but now that's
if you're in the club, if you're in the club, it was all right, but if you're out the club, it's not all right.
That was always the case. It was always a wink.
Is it actually a political decision, or is it about the scope of the European Data Protection Board's adequacy decision making?
I think it kind of goes back to 1948, probably.
I mean, can a political decision be made on adequacy?
Sure. So, I mean, it's all negotiations to a certain extent. If obviously the board will make an adequacy decision, that's separate, but if the UK government and the EU decide to come to some compromise around data protection with the goal of ensuring adequacy, it could occur. I don't see that there's just like if the US and the EU, this is the whole privacy shield, safe harbor nonsense. If enough things change or get modified, if those stars get unredacted, for example, and and there is a compelling enough reason, because it's not like the GDPR is an absolute, right? There are carve-outs and provisions in there about, allowing for national security interests and allowing for, kind of legitimate government interest in terms of preservation of safety and welfare and all those other things. And they're there for a reason. It's because France and Germany and the UK, before they left the club, and probably Ireland and a few other countries, all do this stuff for valid interests. It's just a matter of like being transparent enough about what those interests are and having some level of checks and balances.
So any other thoughts on this introduction from Mark?
Feel free to take an axe to it if anybody wants to. Gotta hit the highlights.
Okay, let's move on to the implications for SaaS. So the first point is transfer isn't about copying. Transfer is about accessing. Any ability to remotely access the data or retrieve it means that it's being transferred potentially to a third country.
I might even change it to processing, because processing is a bit broader. It's it's not just an individual or a system accessing it. It can be any kind of
but it's also, even if you're viewing it from another country, if there's good controls around it, it's going to be okay. It's kind of more than just viewing, for example. If it's totally secure and you've got a secure laptop, whatever that means, there should be no difference between you looking at that, in any part of the world than in the UK.
But if we look at the supplementary measures, it talks about data being encrypted, even if it's only in transit through the third country.
Yeah, I'm not totally sure I agree with you, David. And part of this is because the Data Protection Board and the courts were kind of light on articulating technical controls in the decisioning. But I mean, encryption alone is not sufficient, because part of what the later guidance has talked about is the idea that just encrypting it, just having
yeah. I'm not saying it works, but just conceptually, that was all. Yeah.
I know the Information Commissioner's Office has previously said that if it's just being viewed, it wasn't necessarily a transfer, but I don't think that holds true with the latest guidance under consultation from Europe.
Right. I'm so curious, David, what were you, maybe I misheard you.
Well, that used to be the kind of old favorite trick, wasn't it, with GDPR? I'm an American, and I have an app on there that tells me where my nearest restaurant is. Then I travel to Paris, Now I have location data collected by me by an American company in Europe, and it tells me where my nearest Paris restaurant is. And, were they suddenly in scope of GDPR because they had that app or not? And because it comes under a one-time use, inverted commas, they weren't in scope. So not everything kind of necessarily goes full blown.
I mean, if there are still requirements under Article 4 in terms of, an organization having regular, kind of business dealings or, getting information about data subjects. A one-time use case is not likely to trigger that.
So should we change this being transferred to potentially being processed in?
Yeah, I mean, I would niggle on the processing, because I think in the GDPR, there's, processing is the definition that is referenced in Article 4 and in subsequent articles. And obviously processing goes in the description. It says processing means any operation or set of operations which is performed on personal data or sets of personal data, whether or not by automated means such as collection, recording, organization, structuring, storage, adaptation, alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment, or combination, restriction, erasure, or destruction. So it's a very broad term. It's much broader than just access.
Are you okay with me boiling that down to the word potentially?
Yes.
Great. Okay, so the next point in here is this doesn't necessarily mean it's unlawful. However, if the country in which the data is processed or accessed is not in the European Union, it isn't considered an adequate country, a number of additional steps should be taken, referencing the supplementary measures guidance.
Right. This is the newest batch of supplementary measures, yeah?
Yeah,
Newest
a month
guidance.
old. A month old.
Roughly, I think.
Yeah.
Okay. I'm noting that the US is not considered an adequate country, and I've weakened this down to the UK may not gain an adequacy decision after the transition period. Let's not call it yet.
Correct.
Does the current agreement give us adequacy?
Yes, because you're in the club, or the UK is in the club.
No, I'm saying the deal. So there's the deal or no deal, but is the deal one have
There
adequacy?
is no.
There is
deal.
no deal.
Well,
That's
no,
the
but
whole problem.
No, but the one they iron out, come on, there is already a bunch of stuff out there, right? They just iron out some details.
It might not.
Yeah.
No one knows at the moment.
Yeah, I'm not aware of anyone having said to the press that it did.
Yeah, they're busy arguing about fishing grounds. Data protection is a long way off.
Yeah. Yep.
Okay, so then I've summarized the supplementary measures, not the supplementary measures, the additional safeguarding steps. As firstly, if the legal entity that controls the data in the user's country is not the legal entity that processes and or controls the data in the other country, then the entities must establish appropriate safeguards in the form of contracts between them. Standard clauses are available from the EU, and this is relatively straightforward.
That is one way, yes, but there are other mechanisms. It doesn't necessarily have to be contract.
This is true, there's binding corporate rules, right?
Well, there's binding corporate rules, there's consent, there's derogations. Contracts are a mechanism. Standard contractual clauses are a mechanism.
Would you agree that the primary method is SCCs, though?
I would say, yeah, most companies are probably using SECs. I mean, most company,
There's only 7 BCRs around, aren't there?
Right. BCRs are a pain in the ass to set up. So most companies aren't doing that. Everyone was boilerplating on the SECs, or a lot of people were boilerplating, or legitimate interests and other derogations. And
so secondly, I should probably say the legal entity, must assess whether the contract is enforceable. It is not considered enforceable in the US. As the public authorities are not a party to the contract, they can force a US entity or person to access the data, even if this is remote access. There is no precedent to determine whether UK law will be considered sufficient in this regard.
I don't like that sentence. That paragraph makes me sad. It makes me sad, and let me take a whack at it offline, because there's nuance there that I don't know if I can super clearly articulate. Leave it there, and yeah, exactly.
Does this address that scenario that we were talking last time of data being stored in a UK server by a US company, or a server in a EU jurisdiction by a US company, where they are the legal entity?
Sorry, I spaced out. What?
So the case here is that when you have data being stored in the EU or the UK, but let's say it's the Ireland first, by a US company, right? A US entity, does it fall into this part here?
I mean, if the U.S. entity is obtaining access to, or if is in any way processing that data, the fact that it's stored in Europe is not necessarily controlling, because if they can process it, if they have access, if they can touch on it in the U.S., then these considerations need to be.
Even although the data is only in EU or not in that country.
Right, because again, the central issue is around processing. It's around doing things to the data. The fact that it's stored in the EU is irrelevant. Like it's if I'm Google and I have EU citizen data, say of my employees in Europe, in Ireland, the moment my HR team in America comes and looks at that, that's a transfer. It doesn't necessarily, the physical, the location of the data does not necessarily need to be controlling.
Yeah, but what's the difference between, an European company that has offices in America, that their HR team accesses that data from that company? What's the difference?
Nothing. It's the same problem.
Yeah, but I was saying that data cannot be accessed outside America, outside Europe.
Data, yeah, it can't be in terms of this. In terms of the Shrems II decision, you need to do this calculation. You need to assess the jurisdiction, and the legal mechanisms that are in place. You need to assess whether or not adequacy can be, is likely, whether there's technical controls in place, all these other things, and the supplementary measures. But it's not dependent on the US. It's not dependent on the location of the data so much as the country where processing can occur. So it's a whole data exporter importer thing.
Yeah, but processing, what do you mean by processing? So if I access the data from a web browser, am I processing the data?
Yes.
Yes.
So, okay. So if we have an Irish company, let's say Irish, Guinness, well, maybe, I don't know if it's still Irish. Actually, that's not an island, isn't it? Right. Let's say you have an Irish company, right? Pure Irish, has all the servers in Ireland, right? Has, a bunch of web UIs that are created. When somebody from that company that is in America or in the UK, right? Let's say after, if there's no, adequacy here, when they access that information from their browsers, are they breaking, this?
Potentially. Yeah. I mean, there might be some carve outs for household use for limited exceptions.
I was sure about that, but that's a bit weird to me, right? Because the browser is not processing. I'm not saying this is not a third party taking data transfer. This is just simply web browsing. You're almost saying that you cannot browse your data outside the EU but the data is then delivered encrypted, right, over the browser, right? So,
but it's decrypted in the browser, right?
Right.
I mean, this comes back to the US authorities can compel a US person to disclose that data to them.
Right. Right. And that's the kick in the nuts, right? I mean, here's processing. I'm pasting in the end because it is very broad. It is super long and very involved. And yeah.
I mean, to be fair, if data is displayed in a readable format, it's being processed.
Right.
Yeah, but it doesn't add up, right? Come on. If I'm understanding what you guys are saying, then it's regardless of Shrems II, right? You're basically saying that no data from the European Union can be read or accessed outside the European Union by anybody, right?
We're talking about lawyers, not engineers.
Right.
Practicality doesn't come into it.
Yeah,
Right.
but then but okay, but let's pragmatically speaking, right? We cannot be talking about a problem that already existed before Shrems II, right?
No.
changed?
Shrems II is the FISA 702, which is extraterritorial, which actually kind of means any US company around the world, the US government can have access to it. And that's the real problem. No, it's not just in the US, it's any US entity anywhere.
Yeah, but
Following
it's
the
basically
Cloud Act.
That's the Cloud
Following
Act,
the Cloud
not
Act.
702.
Yeah.
Yeah.
And
Yeah,
what's
FISA
also
702.
changed-
Yeah.
Sorry, go on, Mark.
No. Just the Cloud Act is the one that, coupled with 702, makes any company that the U.S. government can exert jurisdiction over compelled to turn things over. This relates to the Microsoft Ireland case, in which Microsoft had data on a server in Ireland, didn't want to give it to the U.S. government. So the Cloud Act was passed in response to that kerfuffle, even though the courts never decided it. Legislation decided it, or the legislators decided it by passing a law.
And Dennis, what's changed here? You know, the EU has been pretty vague on this previously, and the UK's Information Commissioner's Officer, I understand, has previously said that this didn't count as processing, the example that you gave, but the supplementary measures guidance that we went through last time makes it really clear. So it's only this latest guidance that has thrown this into the spotlight.
Well, that and the Shrems decision, that pesky thing there. I mean, yeah. So, you know, Dennis, the reason that this is now a thing, I mean, it was, if you want to be lawyerly about it, it should have been a thing before, because all these rules were spelled out in the GDPR. But the game that everyone was playing was that, we had this privacy shield thing in the United States, and that was sufficient for creating kind of an adequacy bridge. I hesitate to say adequacy because I don't think that's really what it was designed to do, but it was kind of creating a bridge that would allow the EU entities to transact and do data with the United States. And then once the court said, that doesn't work, then everything got thrown on its head.
But it's still okay. But correct me if I'm wrong, but it's that my understanding of that, even the safe harbor and that stuff, it was for the scenario where a company wanted to process data outside that initial jurisdiction. So in this case, let's say, take the Google example, is where Google, although, for example, some of the data is stored in the UK, they might have servers in the US. They might have servers in that provide other things. Let's say some metadata analysis, some extra things, and they will need to both access the data and transfer data to the US to do the analysis, right? So you're basically moving data around, knowing that you can move data around, right? Look, I had that place where, when GDPR occurred, right? Like one of the companies I was working for, it was intra-company, it was a group, and we had to create cross-group agreements between the legal entities so we could transfer files, in this case, from one side to the other, so you can, photos, so you can process it at a factory, right? So if you have, a company in Germany that you want to factory in France, right? Suddenly, can you send the photos from one place to the other, right? So we created those. So we basically said, okay, as long as we did the requirements and all the stuff and according to GDPR. But my understanding was that if we had a factory in the US, according to the safe harbor stuff, we could still, according that we had the legal contracts, we could still move the data there and process it there. Where what this says is that that technically is now not possible. But in my head, it was always that within companies, not within individuals, right? That's why I was asking that question. I'm drawing the line on a browser versus a legal entity, right?
Yeah, but there's no it's not like a company. It's not like the GDPR specifies that it has to be a company. It's processing. It's much broader than that. And, there's exceptions again for if you want to share an email, or if you want to physically mail a picture to your grandmother who's living in the United States, or, something, that's fine. That's a household exception that's not going to be covered. But, and so that's the envisioned, individual users doing things with data. But you got to remember, all of these things, all this data is housed on machines by companies, right? Facebook, Google, all these are entities. These aren't just people. Like, it's not like a one computer talking to another computer like the good old days of the BBS. Like you have a company involved somewhere in the middle, or a lot of companies involved in the middle. Yeah. And so that's where the processing comes in. That's where it triggers, and that's why there's issues.
Yeah, but the problem here is that with Shrems II is the processing cannot be done outside the EU, at least in the US in this case, right? So you can't process the data in the US. fundamentally.
It is.
Yes.
Yes, it's much more fraught to process data in the U.S. Yes, that's
Yeah.
correct.
And
Unless you
potentially,
take supplementary measures.
Right, that haven't been completely tested yet. But yeah,
but then there's the other scenario, which I think you guys talked about, which is the Cloud Act, right? Where even if the data is being processed in the EU, if it's a legal US entity, you still have the problem that they can get access to the data.
correct.
But that, it does seem to me like it's two separate issues, right? I think they should be dealt separately.
Well, I mean,
Right.
Shrems II did not discuss the Cloud Act. I've discussed the Cloud Act. Mark has discussed the Cloud Act. A few smart people who are paying attention on the EU side have discussed the Cloud Act. But the Shrems decision made no mention of it.
No, but it did say that you should do due diligence on how the legal requirements in that country would look at data.
Correct.
So I guess it does cover the Cloud Act, but not name it specifically.
Correct.
Well, it also, from my reading, so the SECs seem to be preserved, if I'm not mistaken, but you also have, as you said, this due diligence element where the SECs before with the other frameworks were considered adequate. Now they're saying SECs aren't necessarily invalid per se, but you need to understand where the data is going and whether or not that jurisdiction affords is the way that I'm phrasing it, which is not the term of art, but affords the same level of protection.
Aren't they basically just saying if your contract's not enforceable because of your own local laws, it's not enforceable?
Yeah.
They're saying take account of the local context. If you're under US jurisdiction and the US says that particular clause is not enforceable, you can't use it to say we can process that data.
Well, not even the extent of whether or not a particular clause is or isn't enforceable, but whether or not the data will be somewhere where the jurisdiction can do stuff that it can't do where the data lives.
As a sovereign country, which I'm not making any of those claims, we're not going sovereign citizen, but if I say as a sovereign country, any company registered with me, I have the right to access all their data, and another sovereign country says no one is allowed to access our citizens' data without certain protections, fundamentally you've got a conflict there. And even if I, as a company registered with the first country, say, well, we won't let them, it doesn't matter because that's not enforceable.
That sums
So
it up very well.
it's just
That's
saying,
about right.
take account of the legislation that you're registered in, take account of the legislation where your suppliers are registered.
Or in other words, if you're a citizen of Holland and you can smoke marijuana legally there, you can't go to another country and say, I'm a citizen of Holland, I can do what I would do in Holland because you're no longer in Holland.
But we slam into this problem of the internet is not geographical.
Mm-hmm.
Right.
Exactly. So data sovereignty doesn't really exist. It's just a nice concept.
Data sovereignty only exists if I hold the keys to access that data.
Right. If you lock it up and you don't provide the keys to anyone else, then
it's not sovereignty, it's control, because we're not saying it's in any particular country.
Can someone tell me the difference? Genuinely, I'm actually curious about this. What's the difference between sovereignty and control?
Sure. Well, this is not a legal term of art, but broadly speaking, if you were in the United States, for instance, and you had the keys, you could still be compelled through legal or judicial process in some circumstances to turn them over.
Yes, but how if I didn't turn them over?
Pardon?
If I actually refused to turn them over,
then you go to jail, or you.
Yes.
You know.
But the
they
point
can try
is,
to compel you.
They can try to compel you, but sovereignty is about having that control. People can try to compel you, but ultimately, if you refuse to submit to that, you've got that control. So
but you don't really have the control because you're in prison. The sovereignty element would be I'm refusing to do it, and the US government says do it, and you say no, they'll invade you and take you over, in which case they're violating your sovereign territory, which is a violation of customary international law.
Well, think of it this way. Think of it like if you like an embassy, right? An embassy is sovereign of the country that they are representing, right? The US government really can't go in, like the British, I think it was British wife of a diplomat or whatever who ran over a kid, or maybe it was an American. I get confused. Which country? Air
Force. Weird example. That's a specific treaty element. But to take Carrie's example, if you have somebody in the Ecuadorian embassy in London the British authorities cannot invade the Ecuadorian embassy of London because
Yes.
that would be a violation of their sovereign territory and under customary international law causes belli or an act of war.
Yes. There you go. Thank you.
But if I was
stand
not
just
in
better.
the UK, but if I wasn't in the embassy, they could take me and throw me in jail until I agreed to submit the thing, and
No,
I could have the moral victory of refusing to turn over the keys, but I'd still be in jail.
Right.
I agree with you, but I'd still say you have sovereignty over those keys if you've refused to turn them over. It is about the control of that access. We are getting.
You certainly
into
have free will.
philosophy here. Yeah.
Yeah, I see. I propose we move on and let Carrie try and
Yeah.
reword this a bit, unless there's any specific points people don't think are captured in this paragraph that they really want to see included.
Yeah, like I said, I have points about contracts, but that's niggling and all on.
But then, okay, so if you look at 2 paragraphs above, the following steps must be taken to access the data from a country, right? You know, if you take David's point that what matters, well, I think you should take the point of the keys. So in a way, is not just access the data, is to who controls the keys to access the data, right?
But if you can access the data, you have the key to access the data.
No, if you can access the data, you have access to the data. You don't necessarily have the keys to access the information. That goes back to encryption.
Yeah. So you might, maybe when you caveat that by data, you mean unencrypted data. Well, so
Okay.
by information, you mean unencrypted data, probably.
No, I don't actually, because there are other ways that it can become okay, like pseudonymization. So that's probably not the right word.
But how does pseudonymization work? I've now got to have 2 systems, one to pseudonymize, one to transfer the pseudonymization to. If I do it in the same system, I'm no better off because I've still got the original data and I've got the pseudonymized data.
Maybe I can put access personal data, because personal data must by definition be unencrypted.
No, what?
Must be encrypted.
What?
Or
Well, it's not personal data if it's encrypted.
If something is unencrypted, if something is encrypted, and I haven't got the keys, it's not personal data, right? It's encrypted mess.
Oh, I see. Okay, I see what you're saying now. I was deeply confused. It happens a lot.
Is it personal sensitive data, right? Like we have to be careful because there's other types of data, right?
Personal data, all
Personal data. Yeah. But yeah, this feels like this goes back to data versus information.
Mm-hmm.
And Shannon's law.
Yeah, it's personally identifiable information.
No, that's magic US bullshit.
No,
Just
it's
personal data.
It's not. It's information if it's something you can act on, if you can draw conclusions from it. Otherwise, it's data.
Yeah, but don't say personally identified.
PII is a US term.
Then.
PI is a European term, and they're not quite the same.
Yeah.
But information as opposed to data, because they are different things. If I send you a binary string, that's data. If I send you my name, that's information.
Yeah, if you send a business piece of data, that doesn't cover this, does it?
What you mean by a business piece
That's right.
of data? That's broad.
Transaction code. I
Yeah,
send you a payment.
Commercial information, right? Let's say transaction between 2 different companies, or information about a business deal, whatever, right? Anything that actually, here's the question: does this only cover personal data, or this cover data that companies or individuals will consider to be private or don't want to be disclosed?
It only covers personal data, but some business data may include personal data.
Right.
Sure, but so this doesn't include commercially sensitive data.
I mean,
Correct.
it may, because commercially sensitive is a very broad term, but it includes that's why personal data is very specifically defined in a very specific meaning. So.
Yeah, but it's important, right? For the scope of this, right?
For the purpose of this, it's got to be personal information. But you're quite right, Dennis, because I don't know if you guys remember the old Patriot Act. There was a whole kind of rumor going around that actually this was used to find out about commercial sensitive data and give certain countries in the world a commercial advantage because the government let them have access to it.
Yep. but also from a point of disclosure, right? Because isn't part of the problem here what happens when it goes wrong, right? Because if somebody, for example, compromises data, so if there's a data leak, right, that occurs from the US because the US entity accessed data in the EU, right? Doesn't that just makes it even more spectacularly bad? Because they're not supposed to be having access to that data anyway, right?
Yeah. And that's part of the
There's an
technical controls.
Yeah, and that's and also like remember that part of the challenge here is that we're moving to a cloud world, right? Like we're moving to a world where most of our data is now, you know, moving about all these different servers. And it almost feels that what we now need to have is a way to track where the data actually goes and flows, right? It's almost like, what is it called? You know, when you have the supply chain of food, we almost need to start having the supply chain of data, right?
That's one of the things that the European Data Protection Board stipulates, is that you need to have an understanding of where your data flows are going, who you're sharing it with, what you're doing with it, how it's being used.
How many companies do you think know that?
I mean,
not a lot.
it's in the guidance. It's like you know, you need to understand it now. I think a lot more companies know it after Shrems.
I was going to say all of the ones I talk to know it.
Well, it's a massive undertaking, right? But okay, cool. So you're talking about data from a country. Okay, cool. Keep going, Adam.
Okay, so let's move on to the step 3, which is, I think, where we really need to focus. So this is where we can't consider it an enforceable contract. Then we have to take additional measures. Contractual and organizational measures are not sufficient, and that's clear in the guidance. So there's several recommended scenarios that I keep getting this wrong, EDPB, that will be effective. So data is transferred in encrypted form, and decryption isn't possible by a person in the other country. Data is pseudonymized, and de-pseudonymization isn't possible in the other country. And data is only transiting the third country in an encrypted form.
If you go to first and you say it's not possible by a person, surely that's person or entity, right? Because, you know, a lot of this is processed automatically, right? So, you know, and realistically, you know, a lot of this processing is actually done by the server thing, right?
Yeah.
But then if we have the case, so let's take that case. It's a US company, right? Let's say Slack, right? You know, Slack has EU customers. Slack saves the data of the EU company in the UK, right? Or EU, or Ireland, let's say Ireland, right? But does this take into account that although, you know, the Slack data is accessed and maintained only by the Slack employees in Ireland, the Slack mothership and the government can go to the Slack mothership and get access to it. So it is possible for them to access the data, right?
Yeah.
Yes.
So this basically says that if it's a US company owned, right? Or not a US company, look, it could be a company owned by Brazil, right? It could be a company owned by Qatar, right? It could be a company owned by Angola, right? You know, non-EU company. If they have the ability to go to the people who have access and say, give me it, then it can be transferred, right? So decryption will be possible by that person or entity in the other country.
That's exactly right.
Actually, shouldn't you say in the country?
That isn't built into these 3 bullets, because I've tried to align to the scenarios they gave in their report.
Just on that one, when you say country, that should be the unenforceable thingy country, right? Whatever the word for that, right?
Inadequate
country, right?
Mm-hmm.
You know what I mean? So that should be in the inadequate country. That's such a bad word, right? It's like inadequate, but
I don't know. I kind of like unenforceable thingy.
Unenforceable. That's a good technical term.
The thing is there really such a thing as an adequate country? I think it's a nice concept, but I think it's falling apart really rapidly.
That's getting political very quickly.
I mean, it gets political, but there's clearly adequate countries.
But
there's been adequacy rulings.
even on that first one there, what happens if the person who could decrypt it flies into the country for a day?
Yeah.
Yeah, I mean, you could edge case the shit out of this and go down many sad rabbit holes. And yeah, I would be, I would find it hard for say given the data protection authority's current stance on things in most countries, I would be hard pressed to find a company that was flawless and did everything else right, and your man that could decrypt the key flew into the United States, and the government, seized his computer and made him decrypt this. I would be hard pressed to see a data protection authority going after a company for violations. Here.
So let's move forward from edge cases, otherwise we're not going to get through this.
Yeah. Solid.
So the guidance specifically gives an example that cannot be effective in achieving sufficient protection. A data exporter uses a cloud provider or other processor to have personal data processed according to its instructions in a third country if a controller transfers data to a cloud service provider or other processor, and the cloud service provider or other processor needs to access the data in the clear in order to execute the task assigned, and the power granted to public authorities of the recipient country to access the transferred data goes beyond what is necessary and proportionate in a democratic society. And I definitely don't think we should debate that last clause. I'm quoting directly from their guidance there.
Yeah, but does the US today matches that?
No, that's the problem.
Will the UK, if he leaves with a no deal, matches that?
Not
The
according
UK
to the
already
references that I've added.
So that's the thing, right? So
Yeah.
basically you're saying that, if the data is being processed by that entity that owns by that company from that country, it's not adequate.
Correct. So moving on
Nice.
to the solution to this crazy problem.
Yeah.
I tried to add a break.
To be fair, I actually think that you need to have that punchline there, right? Because I think we arrive at it like, we talk for half an hour and then we get to the punchline, right? Which is almost like this means that it is, it's almost like it's not legal to put data, to have data in that.
Yeah,
But I
but
don't think
isn't this session meant to be about workable solutions? That doesn't mean perfect solutions. It doesn't mean exactly legal solutions. It means the ones that will work.
Yeah. But I think we're missing that one paragraph that literally says the problem, right? Literally. And like you just agree, right? So if I say that, does this mean that according to, Shrems II, it's not legal for a US company or inadequate country, i.e. US,
To
right?
store EU citizens' data.
To
or
process, to store and process EU data, even if it's in the EU territory. And let's be clear, is that really what we're saying? And I believe it's what we are, but let's just, we agree to that, because that's the punchline, right?
So in that case, is what we're trying to do define what is your level of risk acceptance?
Well, no, I think we actually are looking at finding a workable solution for this, right? Which I think, let's look at that. But I was saying that, so I was just bold that bit, right? So it is not possible for US entities to store and process EU personal data, even if it's stored in EU territory, right? So like, just to be clear, does everybody in the line here agrees with that statement?
Yeah,
I do.
Because that's massive, right? Like, and I think what's cool is that we now arrive at, like when you said that to me the first time, I was like, say what? Because it hadn't clicked, right? But I think we now start to have good background information for that. But fundamentally, like that's almost the one at the top. Like, Carrie, can I put you on the spot? Like, do you agree with that line? Can we lost that? Okay, Mark, sorry.
Sorry, can you all hear me? My internet connection, it tells me is unstable. Good. It's yeah. I mean, there's some again rabbit holes, right? But there's some rulings in United States jurisdictions where even the temporary caching of a website or an image can be making a copy. So it seems that under this framework, if this is applied incredibly strictly, or to an incredibly strict extent, it does seem to me that it wouldn't really be possible for US companies to store and process EU personal data unless we have some like remote desktop-y, super encrypted-y, cache buffery, wipey scenario. As long as we're using technical terms.
Magic pills to make people forget what they've seen.
Oh, like the Men in Black neuralizer.
Yeah, but look, but let's think about practically, right? Like, this is, look, pretty well, like, in fact, Glasswall, right? Like, we need to now think about this, right? Because if we, especially because of the UK problem, right? Because this becomes even more realistic. If at the moment the US is already a problem, but if UK becomes the same thing and it becomes inadequate from the US point of view, so from the UK point of view, from the EU point of view, that means that we can't process in our legal entity in the UK, process data from EU citizens.
Yes.
Right? Like, let's just be clear, right? And actually, and I think that's what that phrase is very important, right? Like, if we're saying that, it is not possible, is that what we're talking about, right? Let's just be clear, right? Because that is a big deal. And I'm not sure generally possible, right? Like, where are you getting that generally, right? It's either possible or not, right? Without.
I mean, there's some arguments that if you are an entity that is unlikely to get tagged by the government, maybe you can get away with it because
that's security by obscurity, right?
Well, okay, maybe I'll change it to it's not generally lawful.
Well, yeah, I'm actually glad. I'm glad you raised that, because when it comes to certain things that aren't necessarily criminal, sometimes a legal or regulatory or risk decision is a business decision, not a legal decision.
Yes, risk-based controls is what they talk about. Yeah.
Yeah. So if I'm consulted by a company that asks me this, I would lay out the scenarios and say the maximum potential penalty is X. However, you as a C-suite need to decide whether the cost of compliance and the associated amalgamated risk elements are such that it would make sense to ignore this, knowing that you can get nailed for it,
right,
or to try to comply, knowing that it's unlikely that you will need to be responsible for this if you're pursued.
Yeah, and most likely to prioritize the data. I mean, many companies will be dealing with this in terms of sensitive data they hold and plan to get to other data once the regulatory landscape is clearer.
Well, and let's not forget that there's good faith and bad faith elements here. So that if you're a company that is in good faith trying to do the best you can to comply with what your understanding is, you're going to be in far better shape than a company that just says, yeah, you know what, we don't care, we're just going to keep doing it anyway.
But who's going to enforce this?
The data protection authorities.
And what do they run on? They run on Microsoft. Totally. So by the mere fact you're talking to them, they've already broken it. If you talk to the Cabinet Office, they run on G Suite. By the mere fact you discuss it, they're already complicit in what you do. It doesn't make sense.
Right. I mean, there is that argument. That'll be interesting. I wonder if Shrems is going to.
Oh, come on. Aren't there always carve outs for government agencies where they don't have to comply? The U.S. Capitol is riddled with asbestos.
Oh, absolutely. But the mere fact that you can't report it because you'll be breaking it doesn't make sense.
There's a tender out from the UK government looking for a response by January with a value of £750 million for a cloud provider to provide a UK fully owned and managed cloud infrastructure.
Right.
Yeah, I wonder why. Yeah.
Mm-hmm.
And the same is true in Europe.
Data localization is definitely going to be a thing that I think is going to be more advanced. It's going to be pushed more by government agencies and others because of these challenges.
So have we abandoned that whole server embassy thing that we said, where we square off the server room and this corner is Germany, this corner is France, this corner is UK?
No, let's move on to that. Let's move on to that. So,
All right, let's go.
okay, so I tried to break down the functions that email provides. So it's some client-side software, it's web-based access to email, it's cloud-based search of email content, email address lookup, address book storage for external people, features for managing compliance, data loss prevention, security features such as spam and malware detection, and backup.
Don't forget those nifty calendar things where they, add your travel tickets and your concert tickets to your calendar, so you know when the event. I was kind of taking the piss, but you can also have that.
No, but I think you're right, Kerry. Where does it start? Stop and start. When you actually think about email, I kind of use it. The Google one. You've got the Google Meet. You've got all these features, and you kind of think of them just as email. There's just.
So I think we should stick to just email, because the email RFC doesn't define calendar integration. I don't think.
If you wanted to reduce all of those down, everything after cloud-based search of email content is cloud-based search of email content.
Or search of email content, at least.
Yeah, it's just passing the email content by the provider, and what they do with that is a separate thing, but that's where it interacts with email.
You're right, but I think, can I change that to cloud-based user-driven search?
Yeah, but that changes it entirely.
Yeah, but you could see that you could implement just the search as a one-off thing, right?
Well,
Where actually the
Outlook does.
lookup but the other ones actually require, right, data to be in other place. I think is that where you were going, Adam, with
So
it?
you've got cloud-based user-driven search, or just user-driven search, and you've got provider-driven search or provider-driven processing.
Yep, I can remove cloud-based.
And then you don't need to have one for calendar, one for advertising, and so on.
Yeah, no, I think that's a good point. It's a good point, James.
Okay, so moving forward a bit, Carrie, you've got a comment on here about my comment that email SaaS is a duopoly.
Yeah, it's not really, because the only reason I was looking at this is because I'm writing an article separately. It's heavily biased towards Gmail and Apple. Don't get me wrong, but I don't think it's fair to call it a duopoly. Neither one of those are, even in the majority.
These are clients, right?
No, these are different providers. So Google, Apple, Microsoft. Well, Apple iPad is, but Yahoo, and Yahoo. Okay, so I was thinking specifically of, I grabbed the wrong link, but Google, Apple, Microsoft, Yahoo, and
So Apple, you mean people that use like Mac email addresses, mac.com?
yeah.
Okay.
Sorry,
Well,
I grabbed the wrong thing. I grabbed the
Yeah, those stats don't make sense, right? Because
No.
actually, when you look at Microsoft, like they must have a spectacular share on both Office 365 and Exchange Online.
Sure, but I think that if we narrow this to talk about enterprise level,
Yeah.
just because.
Yeah, well, then it's even bigger, right? If you look at enterprise thing, then it's literally Office and G Suite, right?
Yeah. Or so some of us use Zoho.
Oh yeah, Zoho. Isn't that on G Suite now or Google Cloud? I forget.
So I've changed it to enterprise email SaaS as a duopoly. Are we happy with that?
Sure. Yeah. Okay.
I'm
So here we
saying SaaS, right?
here we go. Gmail is 1 billion active. Oh, that's old. Jesus. Never mind. Go ahead. Move on, and I'll.
Okay.
deal.
So while many large companies use on-prem, SMEs and medium-sized enterprises are much more likely to use SaaS. Email represents a huge risk in terms of personal data. I've included the minimum mailbox size for Office 365, which is 50 gig. And as we talked about last time, employers, when they're hiring, process CVs, ID, bank details, social security information, and some of that might be sensitive. I've quoted Google, who said about Shrems II, given the CJEU has upheld the MCCs, it's important to know that your use of G Suite and Google Cloud Platform meets GDPR standards for transfer of personal data outside the EU. And said that's a false premise, because the fact that they've upheld the legitimacy of contracts doesn't lead to automatic compliance when they're used. And this is clear from the guidance. And I've quoted Microsoft, who said something similar and drawn attention to the fact that contracts remain valid without acknowledging any of the rest of the problem. And then I've contrasted this with the statement from EDPB, which states contractual and organizational measures alone will generally not overcome access to personal data by public authorities of a third country.
Mhm.
Lawyers, hit me.
No, I think that's actually pretty right.
But I think it would be good here to make sure that this is not just about Google and Microsoft.
It's not. It's about any email provider. They're gonna have the same. But
Yeah.
he was citing Google and Microsoft because they've made statements.
Yeah. I imagine there's an EU email provider out there making
Wait,
a
isn't it
better statement.
SCCs? Sorry, I'm being pedantic, but isn't it SCCs? I don't know what MCCs are. Model contract clauses? Oh, never mind. Okay, yeah.
Yeah.
It's weird.
Okay.
Cool,
Email
cool.
encryption. So end-to-end encryption was solved in 1991 with PGP, but its uptake's extremely low because it requires work to configure that puts off lay users. For example, Outlook doesn't support it natively, nor does Gmail. Enterprises have generally not favored end-to-end encryption of email, as they have to balance data security against other compliance requirements. Generally, employers want to be able to access an employee's email in a manual or automated fashion for a variety of reasons. Governments also do not encourage the use of end-to-end encryption, ostensibly for public safety reasons.
Yep.
Yep. Pretty accurate.
Okay. Analyzing the generic functions listed above for SaaS email, end-to-end encryption would effectively disable web-based access, cloud-based search, compliance and data loss prevention, spam and malware detection.
So I disagree with access, but I agree with everything else.
I
can-
would do.
And
I
I
agree.
can tell you why, because I had a really cool like end-to-end encryption PGP like thing called Mailcrypt or something like that years ago. And you could,
Mailvelope?
No, it wasn't Mailvelope, but it was like Mailvelope, I think.
Hmm.
And you could slap it. It was an extension, and you could slap it into Gmail and encrypt everything. I could still access email, no problem.
No, agreed.
Encrypted
Proton
everything.
Mail does that as well. I've got Proton Mail and I can access it. So I've removed that error statement.
But everything else
Yeah,
works.
it's almost when you say effectively disable cloud-based search and any server-side processing of data, right? Because it's not just search, right? It's server-side processing of data, right?
Yeah.
Well, it's just any server-side processing, cloud-based search or otherwise. It's anything that's not on the client.
Well, but it's still the data that we care about, right? Actually, and it's actually server-side processing of unencrypted data.
Wouldn't you have metadata technically? Metadata.
Yeah, that has to include metadata.
Right. Metadata would still be processed just by virtue.
Metadata has to be unencrypted because of
Target
the
address
internet.
has to be unencrypted.
Yeah.
No other metadata has to be unencrypted.
See, that's actually an interesting thing because technically, right, we could have a technological solution that encrypts the what's it called, the the part, at least parts of the address, right?
Yeah, we could have a solution that encrypts everything except at some level before the recipient address.
Correct.
I'm going to add metadata to the challenges.
It's actually interesting because, one of the solutions that actually, and James, are we thinking about the same thing? So are you thinking about a service that exists in the safe country, safe environment that is the one that can actually transfer or translate the hash, right, of the destination to the real address.
I'm thinking of bit message. Bit message. All you need is the address you are sending to.
But even that is metadata.
That is, yes. You have to know. You have to have at some point in the clear the place you are sending the message to. You cannot send a
necessarily.
message with no. You cannot
No,
send
you
a message
can.
without a target
No.
unless you are broadcasting it to everyone and only the person with the decryption key
No,
can read the
no.
message.
There's another one. There's another one, right? Let me do a drawing, right? So there's another one, right? Which is basically you saying, if this is you, right, and this is me, and I want to send a message to you, right, on email, right? So let's say this is A, right, and this is B, right? You need the address of A here, right? That's what you're saying, right? Without the little A, I cannot do this.
Okay, address is the wrong word. I need your public key.
Well, no, you need something, right? So that's the interesting thing, right? There's actually an interesting solution here, right? Which might actually be, okay, so work with me on this one, right? If you have, right? And now let me break this into, this is the safe country, or EU, whatever, right? This is the non, basically good country. But, right,
You're about to invent NAT, aren't you?
What I mean NAT?
Network address translation.
Oh yeah, of course.
You're about to invent a address broker. But
Exactly,
that address broker still needs to know who you are. At some point outside of the client, someone needs to have the target address.
Yes. The question is, where is that entity? So
yes,
I would say,
I don't care about that. It's outside the client, so it's not.
No. But from what we're talking about, if that NAT, right? Actually, let's call NAT too. Actually, if the NAT, right, or email address broker, can we call it like that, right? So if this case, if the email access broker is inside the EU, right, then that's okay, right? Because all you need to have here is a hash, right? In fact, you can even have it unencrypted, right? So inside the B bubble, which is unencrypted, you have the address of A. You can actually go to B, right, and say, give me
inside
a hash.
bubble B.
Yeah.
Someone knows your address.
Yes.
That's personal data, let's say.
Yes.
They are within the jurisdiction of the red zone.
I don't think we can go that far. I think if you like I say, if you put that world, then everything, right, is off, right? I think we're talking about the case of the processing entity here, right? The processing entity here.
So we're talking about the receiving email provider.
Yes. Okay. I'm not talking about because that's the point. We're saying that, like you just guys said, like if I'm in a browser and I have a browser extension and the browser extension is encrypting the data, the case that Gary just said, right?
Yeah.
Then it's okay, right? Because the browser.
In terms of threat modeling, they're within our zone of trust. We don't care about anything outside of our zone of trust because we don't trust it. And we don't care about anything inside because we do trust it. We only care about the communications that cross.
Correct. So what we're saying here is that in scenario A, in the current scenario, you were saying that, right, there's all these metadata, the address of A has to be given to this guy here, right? Because he needs to be able to send the email. I'm actually saying that it doesn't, because what you need is you need to send a key that this guy can send the email to that one.
Yeah, so you need a non-attributable identifier that's sent to EAB there, who then knows that it relates to you.
Correct.
But that's still identifiable ultimately to you if they correlate it with access data. And I've just realized I'm going into motivated intruder, which is a whole different thing.
Yeah, but what I'm saying here is that as long as the EAB, the email access broker, is within the EU, is now legal.
Yeah, so you're talking about setting up an electronic dead drop.
James, how do you feel about submitting a paragraph under the challenges section about this?
I kind of got lost about 10 minutes ago, so
Dennis?
Yeah,
Yeah, no, I'll add that.
ultimately,
I think this is an interesting solution because we talked about the idea that
yeah,
we always get
ultimately,
stuck on the metadata.
I semi-agree with Dennis in that it doesn't have to be the recipient address, but it has to be some sort of signifier which is identifiable to the recipient, whether that's through the broker or not. You could link it back. It has to be unique, otherwise the recipient doesn't get the message.
Well, but what if we did what you were saying before, where we just broadcast on a system to everybody at all times, and then only if you pick it up?
Yeah, then we're getting into
not...
blockchain bit message. We put the message out
not...
there, and you use your key to bring it back, but you are still using my public key to encrypt it, which means that my public key is a unique identifier to me because I am the only one who can decrypt it. But it's a whole different thing, and actually, arguably, at that point, you need nothing identifiable to me because there is nothing that necessarily links me unless you're monitoring all transactions. So yes, you're absolutely right. It's perfectly possible to do that if you're doing fully asymmetric.
Computationally
we have
inefficient.
to go down the route of blockchain.
Very impractical,
Can we just avoid?
Really.
It's not impractical. Bit message is out there. It works exactly that way.
But considering the volume of email in the world, we could easily get into the stage where it takes an hour for emails to arrive.
Guys, we mentioned blockchain, so we officially have to all take a drink.
I need
no, but
to
it's like the number stations. We should all just set up number stations and one-time pads.
Well, that's what number stations were. They were blockchain messaging.
So I've tagged this for James and Dennis to expand on. So I've also added the reference to Proton Mail here, which offers full end-to-end encryption, but only things like subject lines, dates, and senders are searchable. But I also found this other alternative, Tutanota,
yeah,
that has search of encrypted data, presumably homomorphic encryption, that is open source. I haven't said homomorphic encryption in the paper because I wasn't sure. But as an example of how encrypted data can be searched without decryption.
If it's not homomorphic encryption, how are they doing it?
Client side.
Well, or you could send tokens to the server, right? So the other way you could do this, right, is if I index your email, right, the email, and I send to the server the tokens of that were on my email, then you could search it, right?
Yeah, I went down that road and then I realized that is essentially a string contains. So it is actually homomorphic encryption going by the definitions.
Mm-hmm.
Yeah. Tutanota, basically just consider it as client side. It's the easiest way to think of it.
Mm-hmm.
So they do the search on the client, so they send all the data to the client.
Just consider it as client side.
Well, that technical difference is a little bit important, right?
Oh,
okay.
I understand why you're saying that, James.
It creates an encrypted search index, yeah, which you search on the client side. Now, there's stuff done to create that search index, which we really don't want to go into, but the actual search takes place on the client against the index.
Yeah, but the point the server has to the data, right? If the server side has the raw data, then they have access to the data, right? So that can't be like that, right? There has to be something else. All right, we're worth looking at it. All right, go back to the where we were, Adam, just on that list of the description. Yeah, with effect disable, cloud-based search and other server-side processing. Well, it's not just such as, right? It's like that's normal for business stuff, right? Just that such as I think is not weird, right? Because and this is usually done by compliance,
Including?
right? Yeah, including compliance, correct. Yeah, that's it. You could add, I could be cheeky. You could add CDR to that, right? Because the whole rebuilding the file into a safe, good state. It's coming. It's the evolution of malware detection, right?
Feel free
cool.
to add it.
Okay, I'll add it. I'll be cheeky to that one. Cool. So, okay, you want to go to the proposed architecture?
Yeah. So I guess I've just introduced architecture, and I've suggested that we potentially need to introduce a trust view. That might show two layers, a trusted layer and an untrusted layer. And this is the diagrams we were drawing up in the threat modeling session last time. The trusted layer would need to be hosted in an adequate country by an organization that could not be subject to US law. The untrusted layer could be hosted anywhere and controlled by anyone. In order to be compliant, the untrusted layer could only process data that was encrypted or pseudonymized. The data would need to be encrypted with suitably strong algorithms, and the private keys might be held by both the end user and the trusted layer of the architecture.
Actually, look, James, right? Our email access broker is defined here as a trusted layer, right? It's just, you know, it's just a part of the component, right? Is to translate random strings into valid emails.
In our threat model, they are within the zone of trust.
Yeah. So the trusted layer, you know, actually might be worthwhile saying that the trusted layer can be providing something like the trusted layer is basically an area to provide multiple types of services. So for example, on here, the trusted layer can be doing actually email storage, email search, address name resolution. Do you know what I mean? So basically you can actually have different services in as trusted layers, right?
Yeah, then you are getting into motivated intruder, where you assume that everyone has the anonymized information and work out whether they could work back from that. And from your trusted layer, if they've taken appropriate security measures not to publish anything identifiable, then yeah, you've got anonymized data. So you have got you've got an identity broker. That's really what you're dealing with.
Yep.
So
no, I think that definition is really cool. Actually, does everybody agree with that? Actually, because I think that's the killer paragraph there, right? So I will put that in bold, right? Like that is.
Say that again, Dennis.
No, you got it there, right? That paragraph there is literally the killer paragraph, right? Needs to be hosted in adequate country.
Ah, right, yeah.
That's the one, right? And trusted layer could be hosted anywhere, controlled by anywhere, which of course now it means the US, right? In order to be compliant, the untrusted layer could only process data that was encrypted or pseudonymized. Bang, right? I think that's the other key paragraph so far. How bold it.
I am going to say you've run into one brick wall here, which is that if you're trying to use it for any sort of communications, if you can't identify the person behind it, which ultimately in this model you can't, unless you're within that trusted zone, you've got a problem.
Why is that?
Because if I'm talking to Dennis Cruz, but I can't prove I'm talking to Dennis Cruz, I can't prove you signed that agreement. I can't prove you entered into that conversation. I can't prove anything, because what you're doing is you're removing identity from it.
I don't agree with that. I don't think this does any of that, right? Well, all we're doing is removing the intermediate people that have access to the data in between two trusted parties. Okay. Basically, all this is doing is saying that between me and you, there is a trusted layer, right? That is now being defined as an entity sitting in EU that has the ability to decrypt the data, modify the data, verify it, introduce keys, do all the stuff.
Yes. So all of my trust as an external party is in them saying that you are you.
Not necessarily. We can swap keys between me and you. But the point is that B.
You're breaking up, Denise.
I was going to say he did just go full Dalek there, didn't he?
Yeah.
So
pause the video and just use audio.
I've kind of left it open where the private keys are held. They could be in the user's hands or they could be in the trusted layer. And I did that deliberately because we're not ultimately trying to deliver the most secure solution here. We're trying to deliver one that's compliant with the guidance.
Yeah. So from the guidance, having that broker is absolutely fine. It's in terms of it being a workable solution, I think there's difficulties.
Yeah. So can you guys hear me now?
Yeah.
Is it okay?
Yeah, but we don't believe you're doing
what I was saying is that my reading on this is we're basically saying that US companies and maybe UK after January cannot be trusted entities. So that trusted entity, that code that runs the trusted bit, who brokers the data between both entities, both sender and receiver, has to be, in this case, in the EU country. Now that service could have all sorts of authentication, identity providers. Doesn't matter, right? But what it means that the legal entity in the US or US legal entity does not have access to unencrypted data. In this case of the email solution.
I can hear this popping sound, and I'm pretty sure it's every single identity provider based in the EU cheering your name right now.
Yeah. But yes, Dennis, I think you're correct.
Yeah, you're right.
Well, and look, I remember once being at the BBC making the case to say that they should be an identity provider for the UK because at least we trust them more than other people, right? But I agree. I think there's, yeah, maybe. But I think that you know, this actually opens up, and this might be the single reason why this might actually have a lot of stick, because it's actually in the EU commercial interest to push this out, because this is actually going to change the center of gravity to a lot of these things to almost EU-based companies, in the EU-based environments.
Yeah, but I don't want to say this, but I'm going to say Estonia.
Well,
who is an identity broker for all of their citizens and all of their e-residents.
Yeah. And they make great beer. So I'm always for Estonia.
The food's fantastic.
Oh,
I wish Portugal could do the same thing. Like, if anybody from Portugal is listening, right? Like, we're more than happy to help set that up, right? Because it's kind of closer, right? And we also got
Portugal,
good food.
Slovenia, just any EU country, I'm happy to help set that up.
And like a country with sun, right? Like good food, right? That's where you wanna. Okay, but all right, but on this. Are we agreeing that that idea is that the concept now here is where does the unencrypted data begin and end?
Yes, it's the trust layer.
Right. And actually, from a threat model, this is actually again.
Wait, is it unencrypted that we care about, or is it identifiable?
Well,
is
unencrypted, identifiable
data, or unpseudonymized.
Yeah.
Because if I'm saying that is going to an identity that I do not have access to, it might be completely in the clear, but I don't know who it's going to, so it's not identifiable.
Yep. I think that's correct. I think that distinction is correct. I think it can be encrypted or pseudonymized. If you cannot, the key is just is the inadequate regime not being able to identify that person. So whatever mechanism is used is whatever.
Yep.
Would you like me to change this sentence?
No, I think that's
that
spot
works.
on. That is
fine.
Okay.
In fact, if you want, that is almost like that's the money shot on that one, right? Actually, you could almost unbold the other one and just bold that one, because that's the paragraph, right? In order to be compliant, the untrusted layer could only process data that was encrypted. No, the one before. That, okay, that's it.
Yeah.
Because I think that's the one, right? Again, what we're saying is the solution here, which, and I think the big bang that you just heard is all these companies would depend on moving the data across, right? Which breaks their business model, right? Is the fact that they cannot do that.
Yeah,
right.
You say breaks their business model, but I can hear at least 3 companies gearing up to build their data centers in the EU right now.
But it doesn't matter because they need to be owned by independent legal entities,
They will
right?
set up branches. They will set up subsidiaries. They will set up fully independent if they have to.
Yeah, they will have to be independent, right?
Google, Amazon, and Microsoft. Is that what we're talking about here?
I was thinking Okta, CyberArk, and there's another one who I can't remember. But they are already identity brokers. They've got the infrastructure. They've got the technology to do this. They've just not got the right regional base.
Yeah.
Cool. Okay. Let's move on to some of these. We've got 28 minutes left. So, functional aspects. So I'm assuming the end user environment, the client side, remains pretty much as it is now. The trusted environment would have a key store holding asymmetric public and private keys for users and fetching public keys from a certificate authority for correspondence. It would also need to have some kind of web server providing user access to email through browsers.
No, so I wouldn't. So the thing about this, right, is that the trust environment is What do you mean by trusted environment? You mean the broker, or you mean the one that provides the service?
I don't think they'd need the web server. They just
Yeah.
need to provide the keys to their users, or actually, they just need to provide the messages. Someone else could provide the client.
Yeah, I think here we probably need to split, practically speaking, between the application itself, in this case, the email, right? And then the entity or some part of the email service, right? And then the entity doing the encryption, decryption, right?
But even if the browser was doing the decryption, surely there'd still need to be a web server to serve up the encrypted. Oh, you mean that could be on the untrusted layer?
The entity doesn't even need to do the encryption, decryption. The entity needs to just do the routing.
Well,
That's
I'm sure that
all they're there for.
Well, I'm sure in practical speaking, this will probably be a REST API or be some API that gets invoked and gets communicated. In fact, I think and this is actually something that's quite important maybe to stress here, is that we're trying to find a solution that the end difference, right? In fact, the biggest pain point here is going to be on the current service providers that assume that their data is kind of available everywhere. But what we're basically saying is that you can still have massive servers, massive scalability, but the only part that your data is in, what do you call trusted environments.
So we're removing this sentence about the web server.
Yeah, I'd say so.
Okay.
I'm not even sure they need the key store. They need an identity store. They need to be able to. They're a NAT device. They're a network address translation. They are purely a routing entity. All they are doing is brokering your identity outwards. That could be through encryption keys. It could be through all sorts of things. It could be just through a lookup table.
But I think we have to be careful there, right? Because I actually think that the trusted environment actually, in practical terms, will have to do processing, right? So if you look at, for example, a server-side email search, what we're basically saying is that the server-side email search will have to be done inside the trusted environment.
Why does the trusted broker, that first layer, have to be the one doing that search?
Well, it doesn't. I think the broker is one element of it.
I've got two reasons why the keys need to be in the trusted layer. Number one is, otherwise you're pushing having to deal with keys to the users. Number two is you can't then put all the DLP and compliance functionality that businesses will want on top of it, because they can't do all that without decrypting the data. Number three is Carrie posted on chat about Tutanota. They've been ordered by a regional court to develop a function that allows it to monitor an individual account. Authorities will want access via the trusted layer and the keys.
No, I think they should have that. I just think they will probably do more than just hold keys. But yeah, I would agree that one of the first major functions of that. But remember that, the point here is that the trusted layer should not be giving those keys to the untrusted party, right?
Correct.
Right, and maybe add something there, like making sure that the keys are not given to the interested party or to the non.
I got it here.
Yeah, and more important, it would provide encryption email content so that. Cool. All right, there you go. Yeah, there's no pass to the untrusted layer. Yes, is it layer or entities? What we called it before.
I'm still going to say I don't think they need to have I don't think they need to have encryption, decryption. They are purely a routing entity. If you reduced it to its simplest form, all they are doing is taking a message from outside and passing it to someone inside without revealing the identity of the recipient to the person outside. They do not decrypt it.
You're right. Purist delivering email, but we want to deliver all this business functionality that all these enterprises rely on.
No, we don't. Yeah. Because if we start delivering that, then we're going to have nation states saying we want access to this account.
Yeah, but
which is fine.
As long as they come from the EU, right? It's okay for US go to a EU country to say, give me access to that data from your citizen. And if the EU country, if Ireland or Estonia agrees that I'm going to give access to that data from my citizen, that would always be possible.
Yeah, but I want to point to them and say, go talk to Estonia Mail.
Yeah, but Estonia Mail will be you know, in sort of required by the Estonian government.
Yeah, and that's
We've-
fine, but that's not my problem as the broker.
Well, it is,
yeah.
isn't it?
Well,
No,
Isn't
because
it, in the tutor nota example, they're being ordered by a court to provide that functionality.
but they're being ordered by a court to provide that functionality because they are holding the data. They're not just brokering it.
But if you're just brokering it, you can't provide any of this functionality like
And
data
you
loss
don't
prevention.
need to. You broker it to an email provider who then does whatever they want with it, whether that's in clear text, client, server, anything. All you're doing is removing that identifiable element to the untrusted party. That's all you actually need to do.
it's more than that, right? Like if you look at the email, we're basically talking about the email. Actually, if you look at email, right, what we're really talking about is that email is a stream, right, of text. The email provider, in order to provide the service that they do today, will need to read the whole email and encrypt it, right? The only question is, who can do that? Can somebody from the US see the unencrypted email, everything, the header, the information and the body and the attachments, or only the
But
end result?
The question is, if we're looking for someone to act as that broker to the untrusted party,
Mhm.
how much do they actually need to do?
Well, so okay. The simplest model, like you said, could be that the only thing that broker does is gives the decryption key to the other side, right?
I don't think they even need the decryption key. They just need that routing map.
Yeah, but okay, putting an engineer hat on, I feel the way this has to work in practice, it can't just be giving a key to the other side. There has to be business logic in the decryption, in the safe harbor layer.
Let me try and understand what you're saying, James. Maybe I can draw some. Can I draw? Can I draw in Google Docs?
I can explain it with carrier pigeons if that would help. No, that's serious. That's not a joke.
Go ahead. Explain it with carrier pigeons.
Okay, I release a carrier pigeon with a code number on it. It goes to its home, it goes to its office. The person at that office reads the code number, maps it to your name, delivers you the message. I have no idea what that message is. It might be encrypted, it might be clear text, it could be anything. I'm inside your trusted zone because the carrier pigeons landed within UK borders or EU borders. Yeah, so geographically sorted.
Yeah, but the carrier pigeon in this case also contains the data, right?
The carrier pigeon contains the data, but that data is not identifiable. That data is not identifiable because that data is mapped to a code.
But if that contains someone's personnel record, it's irrelevant whether it's identifiable to the sender.
Okay, if it contains their personnel record, then yes, you have encryption, but you could do that symmetric, asymmetric, anything else. I, as the person at the pigeon office, don't know or care, and don't need to know or care. And it's better for me if I don't know or care, because then I don't have to build up all of the stuff to decrypt and re-encrypt it. All I have to do is take the message and say, yes, this is yours. We are talking literally natural identity. We're talking an identity broker. And that's all that's needed to make it compliant if you tie it to encryption when you're dealing with personal data, which people already do. So you don't need to start layering all of this extra functionality onto the broker, because the only part that's legally required for them is to remove the identifiable piece.
Well, in this case, the routing piece. So
Yeah.
in the example we talk, okay, so in the example that we're saying here, right? You're basically saying there's two, when the message comes along, there's two parts of the message, right? So if I put the message,
there's the payload and there's the recipient.
Yeah, and both of them are encrypted, right?
The payload can be encrypted. That's quite easy to do end to end. You can do that however you want. Companies can sort it out themselves. That's end to end encryption that exists. The bit that causes the difficulty legally is the routing information.
Well, no, end to end encryption causes a problem legally for companies right?
Yeah, but,
It
but I think
depends
James,
which end, where you want to start the end to end. If I start it at my company boundary and end it at the company boundary on the other side, yeah, I can call that end to end. But that's a problem for the companies. The bit that they cannot deal with, fundamentally, they've got no control over, is that routing.
okay, so what about this? Is this, if, you know, see if this makes sense to what you're describing. This is the untrusted zone, right? The untrusted entity, right? This is the trusted zone, right? And this is the recipient of the email.
Yeah.
Right? So what we're actually saying, in fact, actually, if I put the client here, right? So the client basically has access to so green is unencrypted data, right?
Yep.
So is this kind of what we're saying, is that if I'm on the client, right, I have the unencrypted data, which is the big box, and the unencrypted routing entity, right? In fact, I'm going to have to talk to this guy here, right, to be able to calculate this one here, right? But then I can now encrypt when I send to untrusted zone, now both data, which is this guy here, and the routing data, which is the little metadata, is encrypted. The trusted zone doesn't touch the encrypted data, and actually transforms the unencrypted, and basically the hash, whatever whatever hash is here, gets now transformed into maybe a decryption key that is given to the recipient, who then can do both of them.
Yeah.
Right. So basically, the key part here is this process inside the trusted zone that knows how to basically transform, you know, the red, which can be a hash, can be a token, right, into the green, which is maybe a decryption key. Right.
Yep.
Which, to be fair, like you are right, you know, because I think what that does is that basically makes the identity, the trusted zone is fundamentally an identity / decryption / kind of, you know, and the interesting point here is that it could even be that the trusted zone it's a service that gets provided by this guy. Oops. So you can even basically say that you could even have, for example, in this scenario, you could even have, you know, this guy here running on a browser, right? Let's say, right? So if this is actually a browser that is hosting this, the browser can have an offline conversation with this entity here to give it the keys required, right? To basically transform the green into the red to be sent forward.
Yeah.
So in this case, this trusted zone doesn't even know what that is, just knows that I have a hash, the hash will get this decryption key, hand it over to the next hop down, and the next hop down will be able to access everything.
Yeah.
So technically, if Google moved these servers right here, right, these guys into, you know, actually, but this is the thing, right? So Google will have to move, for this to work, Google will have to move their servers to a trusted zone.
Yes.
Without code changes today.
The recipient has to be within a trusted zone, and the broker has to be within a trusted zone.
Yes. But and by trusted zone, he actually means an EU company, right? In EU data center.
Not controlled by a US entity.
Correct. It has to be a EU entity. So for this to work today without code changes, right? It actually would require that. And it's interesting because
the key thing is it doesn't involve any fundamental changes to the way that the email works or anything else. It's just a routing service.
Yeah.
So all we need is, I think it'd be, if we could add this as a second option, and then potentially we could remove the first option if we kind of align it better.
Well, I think the first option we talked about was also pretty cool, right? But I think we just need to cover multiple options.
Yeah,
right?
the first option is cool. This option I can see venture capital going into.
Maybe we should unshare the Google Doc then.
Let's make all the money, guys.
Well, no, the irony here, right, is that what you actually, the interesting, if you look at, this is where we, you can think of from a worldly maps point of view, right? What we're doing is we're saying the email thing needs to be commoditized. So now if Google plays their cards right, they open source their clients, right? And they allow, that to be, other providers do that, right? Now, the interesting thing is Amazon, if you look at the latest player in Amazon, they actually allowing now, right, the same Amazon environment, the same Amazon workflow to be run inside data centers. So actually, the irony is that I don't know if you saw the latest, ECR anywhere, which is basically the ability to run whatever, the Elastic Container Service, right? Or EC2 anywhere, where basically they're going to allow data centers to run, the equivalent sort of, AWS infrastructure, at least some little bits of it, which will make these actually realistic. So I can have for example, I can have a local data center in EU giving me the same cloud compute, infrastructure that I use now in AWS.
So I'm going to have to drop off in a minute, Dennis. How do you think we should move forward from here? Because I think we've got work to do.
Yeah, well, I think we should do another session, right? And then keep working on the document. And let's do another session, in January. Do you guys want to do 2 sessions, maybe a Tuesday and a Thursday, since we could clearly use time on this? I do want to keep just doing 1 session.
I think more of a gap. 2 days in enough to process everything from the previous session.
All right. Well, I think depends on the things, but maybe I think what might be worthwhile doing is, maybe, let's see who wants to do it. But I feel that if we start to have specific solutions, it might be worth to do maybe a smaller session, or maybe a set of smaller sessions just on laser sharp on the solution, and maybe do a bigger session where we talk more about the overall thing. But I think by now it'd be good to just have, for example, a session around that, maybe the identity broker solution, another one of the, what do you call the safe harbor kind of, your solution one, and then we can have another one where we just go more in detail into the document.
That sounds like a good idea.
Cool.
And I think that the solution James is talking about solves some of the specific challenges that are outlined in here, like the big tech providers have significant cybersec expertise.
Yeah, I think it's an interesting. You see, I feel that there's an interesting legal framework to be thought about this, right? Because you could have a UK legal entity, right, which is almost, for example, a CIC, right, company that uses services from the US company, right? Actually, for the lawyers in the room, would that work, right? So if you have a UK CIC, which actually is a non-for-profit organization, right? Or even a for-profit organization, right? If you have a UK-owned limited company that contracts, let's say, the US, let's say Slack, let's take Slack as an example, right? So you have Slack UK or whatever, a particular company in the UK that contractually, so it's owned by the EU citizens, but contracts to Slack US for the provision of a number of services. Which,
You mean
for example,
an EU? You mean an EU company? You
yeah, a EU
UK.
company, right?
Okay,
so
keep saying UK.
yeah, so Slack comes to the UK, finds a couple European citizens, right? Sets up a EU company in Europe. Maybe it puts in the European stock market, right? Let's say there's even, you could even be a EU limited company, right? But that company has service contracts with US companies, right? But because, and basically, and then Slack says, I'm only going to give my business to such a company, because they can do that, right? They can decide that they only provide the data to that one entity in the EU.
Okay.
That's within the legal rights, right? Like there's no requirement for Slack or Salesforce or Sage or whatever, that company to work with anybody that they don't want to, right? They could choose.
I mean,
you
yeah,
can even
it's just not very smart business sense. But,
no, but
maybe it's something we should talk about in the next talk. I think
Yeah.
everyone's a little fried. I'm a little fried.
Yeah.
And let's make a put a pin in it, put a comment in, and we could talk about that.
Okay,
later.
fair enough.
Agreed.
All right, team. I think it's been great. Another great session, right? Another You guys need to give me some more of those quotes like Adam that you said about the Open Security Summit, right? Because I think that was a very cool comment on this collaboration
Yeah.
environment. And but good. Well, everybody has a great evening. And any final comments, just maybe around the thing you guys want to make?
Just if anyone wants access to the Word doc, I think you've got the link. Just request access, and I'll add you.
Yep. Let me know when you want to move that to Markdown.
I thought it was going to LaTeX.
LaTeX, definitely LaTeX.
Nah, Markdown, man. We need proper
we
version.
need a proper
Markdown.
content system, not Markdown.
I vote latex.
These texts.
LaTeX,
version
LaTeX,
controls.
same thing.
All right.
Pigeons.
Pigeons.
Yeah.
Good night,
Pigeons.
folks.
All right, good stuff, Didar.